Hello dear student, welcome to Theory Masters Learning, your ultimate guide for law. One concept which many students have asked me is the Doctrine of Caveat Emptor. I have received many requests from students to make a video explaining the concept of Caveat Emptor and the exceptions to this doctrine. So here I am fulfilling your request. In this video, we are going to discuss what is the meaning of caveat emptor with examples, and after that we are also going to discuss all the exceptions to this doctrine. If you are watching my video for the first time, I am CA Preeti Aggarwal and I make videos specially for you. Do subscribe to your channel Theory Masters Learning and hit the bell icon so that you get notifications for all the upcoming videos. Also, visit my website theorymasterslearning.com for books, lectures and test series. So let us discuss the meaning of the term caveat emptor. It's a Latin phrase and it means let the buyer beware. Whenever we go to buy goods, will the seller point out defect in his goods? Will he say, no ma'am, this is a very poor quality, don't buy. It won't work after 3 uses. Will the seller tell you, ma'am, don't buy this cloth, it will shrink. No seller will point out defect in his product. Buyer must check the product before buying. Buyer beware. Buyer cannot blame the seller for his wrong or bad selection. If the buyer wants goods of a particular quality, he will have to mention it to the seller. Otherwise, buyer will be responsible for whatever quality of goods he buys. So students, the law of caveat emptor is very clear that buyer, you have to decide whether the goods are matching the quality that you require, whether they are suitable for the purpose that you are purchasing. The burden lies on the buyer. So this is the basic rule which says buyer beware. No seller is going to tell you that these are the defects in my product, don't buy. You have to check the product before buying. The rule of caveat emptor, it means let the buyer beware. Now students, you must be wondering, ma'am, which notes are you referring? So this is my book for CA Foundation Business Laws. You can purchase this book on my website theorymasterslearning.com. My only aim is to simplify law for you. So whatever you find in this book is given in simple, easy to understand language, yet you will find that it is very much legal and can be written in the exam. So we have many examples and everything is given point format. So I prefer explaining from my notes because I know nothing can be simpler than this. Okay, so the expression caveat emptor means let the buyer beware. I'll also give you tips that in case a question is asked, what are the words that the examiner is looking for? So watch this video till the end because you're going to learn the entire concept in detail with examples as well as the keywords expected by the examiner. So the examiner is first expecting you to explain the meaning of only the term caveat emptor. So what will you write? Caveat emptor means let the buyer beware. Is it important for us to write let the? Yes. Should we write it in inverted comma? These are small doubts faced by students. These are all paper presentation tips. Yes, you're supposed to write it in this manner only. Now, according to this doctrine, now what is the meaning of doctrine? It is a guideline or a principle, something which is not written in law. You won't find any mention of this in the act, but these are based on judgments of the court. Like say for example, there was a judge who passed a landmark judgment and the other judges or the cases which were subsequent to that, they also followed the same judgment given in that case. Slowly that became an accepted principle or a guideline, and that is known as a doctrine. Something which is accepted, it is followed by the subsequent judges also. So according to this doctrine, it's a guideline or a principle. It is the duty of the buyer to be careful while purchasing the goods and to ensure that the goods meet his requirement. Now, I'll give you a very small example at this stage, something which I discuss with my students during my lectures. Let's say your mom complains that, you don't eat your tiffin, you don't finish it. That's a common complaint, no, of all mothers. Then one fine day you told your mom, see mom, I can't eat cold food. That is why I never finish my tiffin. So your mom tells you, But I give you warm food. Now, if it turns cold in the tiffin, then what am I supposed to do? I can't come home and come to your college and give you hot food, no? Then go and buy some tiffin that will keep your food warm. You said, very good idea. You went to the shop and you told the shopkeeper, uncle, please show me a very good quality of tiffin. So the uncle showed you various types of tiffins and all of very good quality. So you selected one tiffin, you bought it home and you gave it to your mother and you requested her to give you food in that tiffin. Next day, mom prepared a very nice meal for you and she put it hot, thinking that, it will remain hot in that tiffin that you have purchased, and she gave it to you. In the evening, you came home and your tiffin was full, almost full. Your mom asked you, why have you not eaten the food? Why haven't you finished it? I got up in the morning to cook for you. And you said, Mama, again the tiffin, the food was cold. Now I can't eat cold food. But you bought this tiffin box. Go and give it to the shopkeeper and ask him why the food was not hot. You went to the shopkeeper and you said, क्या अंकल, बच्चा समझ के आपने मुझे कोई भी टिफिन दे दिया, इसमें तो खाना ठंडा हो जाता है. The shopkeeper looked at you. My child, you did not ask for a tiffin that keeps the food warm. You just said, give me good quality tiffin. I showed you good quality of tiffin. Unless and until I know the purpose for which you need, unless and until I don't know what quality you need, what is your requirement, how am I supposed to be blamed? So the seller is responsible for his choice. The seller has to ensure that the goods meet his requirement. Okay, so in this case, can we blame the shopkeeper for giving you a tiffin in which the food doesn't remain hot? No, we can't blame the seller. We'll have to hold ourselves, the buyer, responsible. So the seller is not bound to disclose the defects in the goods he is selling. This is another provision that yes, the seller will never say that my goods are defective. Buyer has to check them before buying. That is what our parents have also taught us. You go to buy an electronic, just check. If you, let's say, go to buy a calculator, okay, you check 2 plus 2 is 4. Okay, you check few basic multiplication, is the answer coming correct? Yes, that is what we have been taught, because we know that later on, if any defect comes up, the seller will not accept a return of goods, no? So you go to buy cloth, you go to buy anything, you first check and you recheck before buying. You confirm whether the goods are of the quality that you require and there is no defect. It is the duty of the buyer to examine the goods thoroughly and to satisfy himself that the goods which he is buying will serve his purpose. So therefore, while making the purchase of goods, buyer he must rely on his own skill, and if he makes a bad choice, then in that case, he will have to hold himself responsible for his bad decision. So students, this is the introduction that you will give in case a question is asked on caveat emptor and its exceptions. You can write examples in the exam, but I don't think it is required. It is not something expected by the examiner. So what are the keywords that you will include in the answer? So the first thing is we will write the meaning, that is, let the buyer beware. It is the duty of the buyer to be careful, that you can write it in your own words. Seller is not bound to disclose the defects. So he is not bound to disclose the defects. This is something which is expected by the examiner. You have to write this in your answer. Seller is not bound to disclose. It is duty of the buyer. So you need to mention the word duty, to thoroughly inspect and satisfy that the goods which he is buying will serve his purpose. So it is duty of the buyer. So while making the purchase, if the buyer depends on his own skill and he makes a bad choice, he will have to hold himself responsible for his own bad decision. So this you can frame and write in your own words. Okay, so while making purchase, the buyer depends on his skill, then he will be responsible. Many a time students at this stage ask me that, ma'am, but this is not always true. Like once I purchased a cloth and I did not check whether there were any defects. At home, I checked everything. I found that there was some minor defect. I went to the shopkeeper, he exchanged it, or he asked me to buy something else. So it's not always possible, no, that caveat emptor will apply. In today's market, students, this may not apply because it is a buyer's market. Buyer is the king in today's market because there are so many sellers available. You have so many choices. Nobody wants to lose a buyer. So in today's market, yes, many a times you will find that caveat emptor does not apply. In fact, it is the seller who has to be aware now. But yes, there are cases wherein it is clearly mentioned by the seller that goods once sold will not be taken back. We will exchange, but we will not give you money back. Buyer has to check the goods. So it may be a condition of the seller that I am not going to, take back the goods. In that case, we can't argue with the seller. Also, you go to return, seller may refuse, saying that no, you should have checked. Now that you have opened it, now that you have used it, I will not exchange it. So the ultimate decision is that of the seller. He can refuse even in today's market, and you won't be able to argue. There are examples like A purchased 5 meters of cloth for stitching. This fact was not mentioned to the seller. Cloth was found not suitable for stitching into a suit. So caveat emptor being the rule, A can neither reject nor can claim refund of money from B, because he should have checked the cloth before buying, whether he should have checked whether it is meeting or suiting his purpose or not. Seller sold pigs to the buyer without informing him about certain defects. Now the pigs were sold at an auction with all faults. Seller knew that the pigs were suffering from swine flu, but he did not inform the buyer about it. All the pigs died, and they also infected the buyer's own pigs. So it was held that seller is not bound to disclose the defect in the goods. Buyer, you have to check the goods before buying. See, it was sold with all faults. So you have to check whether there are any defaults, something, which can be found with reasonable, apparent inspection. So in this case, the buyer has to check the goods. He has to inspect the goods. Buyer will have to blame himself for apparent or visible defects. Then ma'am, what about hidden defects? Like we could not come to know about it even after examination. Then for those hidden or latent defects, seller is liable. Do you want me to give it to you in writing? Do you want to write it? Yes, come on. In my lectures, normally we do this. We explain and we also, give students time to write. So let me do that for you also. So in case of apparent defect means visible. Apparent means visible. Okay, in case of apparent or visible defect, who will be responsible? Yes, it is responsibility of the buyer. Who is responsible? Buyer. You can write it over here, students. But what about hidden, also known as latent defects? In case of hidden or latent defect, you will not come to know about it after reasonable examination. Latent defects are known only when you use the goods. Okay, so this you will find only upon use of the goods. Who will be responsible for hidden defects? It is the seller. Okay, it is the seller. All right, the defect was apparent, but the buyer did not inspect. The buyer will have to blame himself. Yes, he will have to blame himself. So buyer will be responsible for apparent or visible defects. Now, in these cases, the basic assumption is that buyer must check the goods before buying. But that's not always the case. There are certain exceptions. Under these exceptional cases, buyer is not liable, seller will be responsible, and you will understand why. What if the buyer makes the purpose known to the seller? Okay, I had informed the seller that I require a tiffin box which will keep the food hot or warm. I had informed the seller about the purpose. Okay, what if I had informed the seller? I'll just highlight the points for you. The buyer makes the purpose known to the seller. This is the first requirement. He relies upon the skill and judgment of the seller to select the best goods because the seller has been dealing in those goods since a long time. So let's say that this time I went to buy a tiffin box and I asked him specifically for a tiffin box that will keep my food warm. And he says, better take this. It will keep your food warm. I relied upon his judgment because I thought he has been dealing in tiffin boxes since a long time. He knows better than me. I purchased it. If then I find that the tiffin is not suitable for my purpose, buyer can't be blamed in this case. Seller will be liable. We can reject the goods. We can claim full refund of price. Okay, then it is the duty of the seller to ensure that the goods are fit for the purpose. If the goods are unfit, the principle of caveat emptor will not protect the seller and he will be liable for damages. So this is just an explanation of the effect, that if we rely upon the seller's skill and judgment, and if the goods are not as per what he claims or what we require, then you cannot blame the buyer. Seller will be responsible. Where the goods are bought under brand name or patent name. See, if you are buying the goods under brand name or patent name, it is actually duty of the buyer. Like, I went to the shop and I asked for Bonvita. Okay. I asked for Bonvita. The seller gave me a bottle of Bonvita. I consumed many bottles, but I found no improvement in my health as it was claimed in the advertisement. Can I blame the seller? Can I blame the shopkeeper for it? That you gave me a health drink which did not provide me with any health benefit. I relied upon the trade name, the patent name of Bonvita. I cannot blame the seller. But what if, variation, I went to the chemist and I told him that please give me a health drink that will improve my health, it will make me very strong, and he suggested Bonvita. Then if I find no improvement in my health, can I blame the shopkeeper in this case? Yes. So if we rely upon the brand name or trade name, then there is no implied conditions that the goods shall be fit for the purpose. In this case, the buyer will be responsible because he buys it under brand name. However, the condition is applicable if the buyer relies upon the seller's skill and judgment. In that case, the rule of caveat emptor will not apply. We can hold the seller liable because we relied upon his skill and his suggestion to buy Bonvita. So the rule of caveat emptor will not apply. Whereas if we rely on the brand name, so in this case, the rule of caveat emptor applies. Students, this is a particular provision which you can write in your own words. This is something which you can explain in your own words depending upon your understanding. Okay, you need not write these exact words. What are the keywords? I have highlighted points A, B, and C in the first provision. And in the second exception, you can write it in your own words. What we need is buyer relies upon his skill and judgment. Sorry, buyer relies upon the seller's skill and judgment. Then in that case, the seller will be responsible. Caveat emptor does not apply. What if the goods are bought by description? Okay, I'll just highlight this. Goods are bought by description. Okay. Then what is the implied condition? The goods shall correspond with the description. What if they are not as per the description? Then can we blame the buyer for it? You bought goods from Amazon. Okay. Let's say, take the example of Amazon. You have purchased the goods reading the description. If you don't find the goods as per the description, you can reject the goods. You can say it is not matching the description. So where the goods are bought by description, the seller is responsible if the goods are not as per description. You can't blame the buyer. He has not even seen the goods. He has only bought on the basis of description. Over here, there is another requirement that the goods should also be of merchantable quality. Now, what is the meaning of merchantable? Merchantable means fit to be sold. The goods should also be fit to be sold. Now, I purchased a bag from Amazon after reading the description. The goods are, yes, definitely not as per the description. In fact, they are not even of merchantable quality. Or it may happen they are as per description, but they are not of merchantable quality. What is the meaning of merchantable quality? When I opened the bag, I saw that the zip was of very poor quality. In fact, the zipper was very tight. Alright, I checked the material. It was extremely thin. I was wondering, how can a person even sell such poor quality of goods? So it is not something which you can sell. Okay, the zip was not working. Maybe it was torn at one place. The net that was there to keep the bottles, that was torn, that was coming out. This is not even of merchantable quality. You can reject the goods. So it may sometimes meet the description, but it is not of merchantable quality. You can reject. You can't blame the buyer for that. What if the goods are bought by sample? I saw a sample of rice and I ordered 100 bags of rice on the basis of that sample. Now, what is the implied condition over here? That whatever bulk I receive should correspond with the sample. The buyer must be given an opportunity of comparing the bulk with the sample, and the goods should be free from latent or hidden defect. So what are the conditions? See, it is mentioned over here. The goods should be, the buyer should be given an opportunity of comparing the bulk with the sample. The goods should be free from latent or hidden defect. They should be as per the sample. Okay, so this is, so they should be as per the sample. This I'm just reminding you of the provisions. They should correspond with the sample. Bulk should correspond with the sample. I must be given an opportunity of comparing the bulk with the sample. And they should be free from hidden defects. But what if I was not given an opportunity of checking? All right, I checked, but the defect was hidden. Like when I saw the cloth, it was fine. But when I put it in the water for dyeing, it shrunk. How will I know about this hidden defect unless I use the goods? So the goods should be as per the sample. They should be free from defect. If they are not, you can't blame the buyer for that. Seller is responsible. Goods are bought as per sample as well as description. Then what is the condition? Implied condition. The goods, very good students, the goods must correspond with sample as well as description. What if it is not? Can I blame the buyer for that? Seller is responsible. There is an implied condition as to quality or fitness if annexed by usage of trade. So sometimes there is nothing written in the act. See, whatever we discussed above, no, everything is mentioned in the act. But what if it is something which is not mentioned in the act? It is annexed by usage of trade. Now, what is usage? Now, usage, they are repetitive acts. They are unwritten rules. When these repetitive acts, they are, followed by many, it becomes a law which is known as a custom. Now, usage is unwritten rules. They are unwritten. These are followed in a particular line of business since many years. Like say for example, in case of partnership, your deed is silent, but your trade custom allows you to give interest on capital, salary or remuneration. So law says that you will get interest or you will get salary if it is a trade custom, if it is a usage, something which has been followed since generations in my line of business. So it is not written somewhere, but everybody gets interest, everybody gets salary. Similarly, there are certain conditions as to quality or fitness which may be annexed, which may be attached by some trade custom. If it is not present, can you blame the buyer for it? No, it's the seller's responsibility, to ensure that the goods are meeting the purpose, they are of the quality as demanded by the trade custom. You can't blame the buyer if it is not meeting the requirement. Seller sells the goods by making certain misrepresentation or fraud, and the buyer relies on it. Misrepresentation, fraud. Tell me, students, the contract is superb, brilliant. It is voidable. Yes, the contract is voidable. At whose option? The buyer, person against whom we are using misrepresentation or fraud. So where the seller sells the goods by making fraud or misrepresenting the facts and the buyer relies on it, or when the seller tries to actively conceal the defect. Do you remember we had discussed that active concealment amounts to fraud? So if you actively conceal, or it is some defect which could not be which could not be discovered by the buyer on reasonable examination, again it is talking about hidden defects, latent defects. Okay, these are all indications of fraud. Then in this case, caveat emptor will not apply, buyer beware will not apply, seller will be liable. In such a case, the contract is voidable. Buyer has the right to avoid the contract and claim damages. So students, these are the exceptions to the doctrine of caveat emptor. I hope you understood everything properly. I'll just zoom in a little so that you can see the notes which I have written, and you can copy them down in your notebook or whichever book you are referring. If you would like to access these notes, then the link is given in the description box. Let me know whether you enjoyed watching this video, and also tell me some other concept in which you have a doubt. I will definitely make a video on that concept. Alright students, so I'll take your leave. Stay happy, keep learning, and subscribe to your channel Theory Masters Learning.